Good afternoon, everyone. My name is Camille Shaw, and I am the project director of the South Carolina MBDA Business Center, which is operated by DITSA. Welcome back to session 3 of the 4-part series on succession planning. In case you missed session 1 and session 2, they are now available for you to replay them on our YouTube channel. If you missed these sessions, we will add them momentarily, a link in the chat room. So be sure to check the chat room. Oh, and I see it right now. It's in the chat room. Okay, next slide, please. So before we begin, let me give you a quick overview of the center and thank our sponsors once again. The South Carolina MBDA Business Center is funded by the U.S. Department of Commerce, Minority Business Development Agency. We work with small businesses throughout the state to help them to scale up, build capacity, and grow. So thanks again to all of our sponsors for supporting us with this very important initiative. Our sponsors include the U.S. Department of Commerce, Minority Business Development Agency, the City of Columbia, Michigan Minority Supplier Development Council, iSuccess Consulting, and DITSA Inc. So joining us again today is our dynamic and energetic facilitator, T. Renee Smith of iSuccess Consulting of Atlanta, Georgia. T. Renee is the CEO of iSuccess Consulting. She is a second-generation business owner with over 25 years of experience in corporate strategy, supplier, and leadership development. T. Renee has raised more than $30 million in capital for small businesses and has managed multi-million-dollar budgets with Fortune 500 corporations. Ladies and gentlemen, let's put on our thinking caps and join me in welcoming Ms. T. Renee Smith.
Welcome, welcome. Hello, hello. How is everybody doing? Hopefully you have not just finished eating lunch and you're sleepy. Hopefully you are wide awake and ready to attend today's session. So let me just do a check with everybody that's in the group. Get your chat ready and let me know on a scale of 1 to 10 where you are. Panelists, I want you to do it as well. 10 is I'm so excited to be here. I'm wide awake. I'm ready to go. 5 is y'all have no idea that I still have on my pajama bottoms. I'm barely here. And 1 is I am hanging on and I'm gonna have to watch the replay. So let me, woo, okay. All right, so we have some 10, some 8, somebody is off the scale with a 12. Awesome. So whenever we get 6, 7, 8 and above, that means that we don't have to work as hard, right? If y'all are on 2, 3, 4, that means that we have to work hard. Let's see, Nickling is 9:04 a.m. here, but you're still on 10. Awesome. And the next question that I have, is this your first session or have you attended all 3 or have you attended 2? I just want to see who's in the room. Drop in the chat and let me know if this is your first session, if you've attended 2 or if you attended all 3. All right, Nickling, it's your first session. You're in for a treat. Oh, so we have a lot that have attended all 3. We have some that are 2. Angela, you're first. Laura, you're first. All right, awesome. Third, so excited, Jill. Yes, Carolyn, all 3. Wendell first. Okay, so for everybody that this is your first session, it is going to be a treat for you. We really kind of pull back the layers and our panelists, they give you the raw truth, the real and unfiltered truth about whatever our topic is, and they share their personal stories. So no question is off limit. So when you have a question, just drop it in the chat, or if you have a comment that you want to share, put it in the chat, or if you want to send a message directly to one of the panelists, you can do that as well. So this is very engaging. We're not going to talk at you. We're going to talk with you. Okay. So now I'm going to introduce our amazing panelists. So first of all, we have Charles Boykin, and I told him that he wore his power bow tie for us today. So y'all are getting a special treat. So Charles is a graduate from Benedict College, and he's the founding partner of Boykin and Davis, a Columbia-based law firm specializing in labor and employment law with an emphasis on school law. He is the chair of the South Carolina Legal Services Board and a member of the South Carolina Access to Justice Commission. He's also a former member of the Board of advisors to the Charleston School of Law. Now, Charles is an ordained Baptist deacon at St. John's Baptist Church in Columbia, South Carolina, and he is a member of my brother fraternity, Omega Psi Phi. So now Charles is going to have about 3 closings at the end, and so y'all just wait till he gets to the 4th closing, and then the session will be over. So I just want to warn you that the Baptist deacon might come out in him today. Okay, so everybody, let's give Charles a warm welcome. Okay, so next we have Donnie Burkett. And so you're going to see Donnie and Alan go back and forth. They have like this love kind of relationship where they're always one-upping each other. So if you see that displayed here today, it's fine, it's normal, it's just what they do. But they really do like each other and they really do respect each other. Okay, so I just wanted to put that out there. So Donnie is the executive vice president of Burkett, and Burkett. Yes, Burkett to the 3rd power. So he'll have to explain that story to you and tell you which Burkett he is. And they are a certified public accounting firm, and it was founded in 1976 in West Columbia, South Carolina. This means that he has years and years of experience and he knows what he's talking about. So whatever questions you have reference to accounting, you may want to ask him here because his billable hourly rate is very high. So whatever your questions are, you might want to drop them in the chat. So Donnie is a member of he's a member of Resource One Health Management Services since 1996, and he's a member of Burkett Financial Services since 2002. Let's give Donnie a round of applause. All right, and last but not least, we have E. Allen Hancock. And now, if you see him put his glasses on and get real close to the screen, that means that he's really about to tell y'all something powerful. So y'all need to pay attention. So E. Allen Hancock, and he has to tell us what the E stands for, is a senior vice president at First Community Bank and the director of First Community Financial Consultants. He was born and raised in Columbia, South Carolina, and is a graduate of Spring Valley High School. After earning his BA degree at Erskine College, Allen returned home to Columbia, where he spent 32 years. Yes, 32. He looks young, but he's experienced, career in the financial services industry. The majority of that time was spent building a financial advisory practice of his own, which he ultimately sold to First Community Bank in September 2008. So he is now working with the bank that he sold his company to and living his best life. So let's ask him how he did that. And so finally, Allen is a certified financial planner, practitioner, and a chartered retirement planning counselor. So again, the questions that you have in reference to certified or the questions that you have and you want to get information from a certified financial planner, you need to drop it in the chat today. All right, let's welcome Allen and all of our panelists. All right, before we get started, we have a poll, and then I'm going to ask the panelists to really talk to us about their entrepreneurship or their small business journey. It's one thing to hear their bios and how impressive and amazing they are, but we like to hear what was the real story? Like, how did you get to your business and what were some of the obstacles that you overcame? All right, so first, drop in the chat. Do you currently have an estate plan? Yes or no? And if you have to ask what is an estate planning, then your answer is no. Okay. All right. Oh, and we can put the poll. Actually, y'all dropped it in the chat. Can you also just click on the screen with the poll so we can see the percentages? Forgive me. I apologize. I'm making you do double work. Can you just drop on the screen and let us know how many of you all have an estate plan? Yes or no? And it looks like in the chat that most people are no, but we'll just see it on the screen. All right, we can close the poll. Okay, so the majority of the people do not have an estate plan. Jill says, I have a will, but not an estate plan. Okay. All right, next question, please. Does your business have an attorney? Yes or no? That you're able to go to for business questions, whether it could be strategy or contracts, documenting your will. Does your business have an attorney? Yes or no? All right, let's close the poll. We just like to see who's in the room. Okay, so about 60% do and 40% do not. Okay, thank you. All right, last question for you. Last poll question. Does your business have an accountant, or are you the one that's doing all your books? And when we ask about the accountant, it could be someone that is doing your financial planning. It could be someone that's doing your tax, or someone that's doing your outsourcing your bookkeeping. Does your business have an accountant? Yes or no? All right, let's close that poll. Okay, good. So 74%. So the majority of you have an accountant, the majority of you have an attorney, or at least over 60%, but the majority of you do not have an estate plan. Jill, what do you say? But my accountant and attorney are overextended. And Nicolene said, does Legal Shield attorney count? Okay. All right. So next slide, please. So before we get into the nuts and bolts of estate planning, I would like for each panelist, starting with Alan, then Charles, and Donnie, to just really talk to us about your entrepreneurship journey and kind of some of the struggles that you had and how you overcame them. We always like to personalize our connection with our panelists.
Me first?
Absolutely.
Okay. I'm Alan Hancock with First Community Bank. I guess my journey to where I am now is maybe not that different than where several of you are. I went to work for numerous corporations right out of college, knew I loved the financial world, had a lot of people in my life in the financial world when I got out of school. Was told, go work for a company, figure out what you want to do. And I did. And I kind of figured out that I loved giving people good financial advice. I also learned I didn't really like the way most of those companies asked me to do it. It seemed to be more bottom line for the company than for me or my clients. So I did what every young, brash person that thinks they can rule the world does, and started my own business and said, I'll do it my way. I don't even think I've said this to any of the facilitators of the event. I was so prepared for that not to work that I actually had accepted a coaching and teaching position back at Spring Valley High School. And since we have a Baptist deacon on the panel, I'll say I think the Lord led it to work so well that I never had to fulfill that coaching or teaching position. So I did. The business really kind of, took off and did extremely well. And then I realized I had to start practicing what I preach to all my clients and ask myself the tough questions. Do I really love business owning, or do I love giving clients quality financial advice? Because whatever you do really well in your business, if you've done it successful enough that the business is becoming a beast of its own, you're probably on this call partly because you're trying to wrestle that monster to the ground. And we work hand in hand with clients all the time that we force themselves to ask that question. The analogy we always use is sort of a medical analogy. Do you want to be a great surgeon, or do you want to run the hospital? Because those two things are usually very different. And when I was honest with myself and answered that question, I decided that I want to give people great financial advice. That the difficulty of employees and staffing and payroll and taxes and all the stuff that the chat folks just said they're struggling with was not what I wanted to do. So I sought a buyer. Found one in First Community Bank that I absolutely trusted, that I knew would help me carry on my version, just maybe with their money. And now 15 years later, so half my career was on my own, and now I've now been doing this almost as long as I was on my own. And for me, it was a great move. I wholly extol the virtues of answering that question for yourself, figuring out what it is that you want to do. And then making your plans accordingly. If you love business owning and that's what you want to focus on, then there are steps you need to take to make sure that gets continued on. And if you don't, if you think like some of the burdens of owning a business are starting to mount on you, then there's some things you need to do to probably help, alleviate some of that from you with also some continued planning and stuff like that. So, yeah, I know we'll get into a lot more of the actual specifics of maybe my sale and how we did that, but for now, is that a good enough recap?
That was great. That was great. And Jill said such great advice. And so I want to ask the group this, and this is not a poll. So I really want you to put it in the chat. You said, do you want to be a great surgeon or do you want to run the hospital? So what that essentially means is, do you want to act in the CEO role and really be strategy and managing the people and managing the company? Or do you want to provide the service? So I want you to think about it for a second, and I want you to drop in the chat. Do you want to be a CEO or do you want to provide the hospital? Lakeisha said, I want to run the hospital. Patricia said CEO. CEO, okay. So Jill, you want to be the surgeon. Gabriella, CEO. Milna, CEO. All right, we have a bunch of bosses on this line that want to tell people what to do. So basically some control freaks that want to be the CEOs to run the business. Okay, so if we look at the poll we look at the chat right now, most of the people want to be the CEO, right? We do have a couple that want to be the surgeon, but most people want to run the hospital. Okay, I'm succeeding the CEO position. Okay, I love it. I love it. Okay, so it's great because as we're doing the business succession planning sessions, it lets you know the role that you need to be in. It lets you know the team members that you need to have to support you in your role. Okay, Charles, can you let us know about your entrepreneurship journey? And then Donnie, we'll get to you.
Okay, thank you, Renee. I'm a graduate of Benedict College. I know that was said once, but some people may have forgotten that it's here in Columbia. After finishing Benedict, I went to graduate school, received a master's in public administration, and I worked for roughly 10, 12 years for various local governments across the state. By most measures, it was fairly successful, but I always kind of wanted to go to law school. I was living in a place called Anderson, that's in the northwestern portion of the state, and coming back and went to law school. I graduated from law school at 40 years old. By most measures, and even mine then, I was old. And I wanted to practice law and I wanted to do government work. One of my professors came to me and said, I think you will be a good trial lawyer. And so I really wish you would go to work in private practice before going back to the government. And my answer to him would have been no, but I had already submitted my application for the bar and he was one of my references. So I didn't dare disappoint him on that point. So I went on, accepted the firm's offer and worked there for about 4 years. The firm then split up, which is what law firms tend to do. And I went with one part and worked for a few years and then decided I wanted to do this on my own. My partner, Davis, he and I were classmates at law school. He was much younger than me, but we were classmates. And my desire was I wanted to see whether or not I had the steam to move under my own muster. And I like practicing law. The business ownership piece is a different story. Between the surgeon and the CEO, I would prefer to be the surgeon. I would like to be the one that's rendering the service. So in 2005, Mr. Davis, Kenneth, and I opened this firm. And we opened it primarily to do labor and employment, emphasis on school law, but we've expanded to an institutional practice where we represent institutions of higher learning, colleges, universities, cities, counties, continue to represent school districts. We'll also represent churches and other nonprofit, fairly large organizations. And we range anywhere from 6 to 9 employees at any given time, and that's about what we do. We're talking about our succession group, or we're just talking a little about who we are in the world right now.
Just your entrepreneurship journey. We're going to get to the succession,
Okay.
but Charles, you hurt my heart when you called yourself old at 40 because I'm past 40. Like that hurt me. So I just reframed it in my own mind that you meant wise.
Okay, I'll accept the wisdom as long as you don't tell my wife and my 2 children that I'm wise, because they still think I'm the dumbest man in the room.
That's just our little secret. You just have to let them believe that, and then you go run everything. Okay. Let's see. Charles, my cousin started his medical school at 40. Okay. All right. Anybody else in the 40 and over club here? If so, we're just gonna go with wise and we're gonna go with seasoned. Okay. All right, Donnie, Mr. Wise and seasoned person, you go ahead and come and tell us about your journey, your entrepreneurship journey.
Well, as I said earlier, the name of our firm is Burkett. I tell everybody I can read their mind because they're trying to figure out which one I am. My Burkett's first. I started the firm in September of 1976. And if 40 is wise and what do you call it, I'm in 70. So we'll figure out what that means a little bit later. That means a lot. I'll also say one thing about Alan's question. Alan does a great job with the business. I have for 8 years been on the board of Lexington Medical Center. The last 2.5 years, I have been the chair of the board. And you don't want to be the CEO of a hospital. I can tell you that, all the red tape stuff you go through. It's a tough job. If somebody says they want to do it, well, I hope they can do it. It's a tough job. But just my journey is kind of a little journey like everybody else's. I was in high school. I took a job working for a large grocery store here. It was the largest one in Columbia. I worked there for 2 years for college. And my freshman year in college, they came to me, and also my twin brother wanted us to be part of management. And at that point in time, I didn't know much about how to run a business. I knew how to manage people, maybe. And I sat down and met with a guy that's a CPA, and he helped me understand. And let me just say, some people don't know what a CPA stands for. It stands for Certified Public Accountant. My daughters say it stands for Chiefest Person Alive. So it's probably some disparity in that about what it is. But so he helped me develop procedures to figure out how profitable business was every week and what I needed to do for the next week to help the business become profitable. And he was charging me so much per hour, but also helped me become very successful at what I was doing. And I thought math was easy for me. It was one of the subject I really enjoyed. And I changed my major in school and became a CPA. And that's really the crux of the business we have here. We've had I've been in a number of different business ventures, but here at the CPA firm, we do a lot of things for different people. We do tax returns, we do audits, we do just regular financial statements. However, we do a lot of tax planning. That's what we specialize in for people who may be selling a business, doing something else. We also do a lot of consulting. And that consulting, a lot of it ranges from hoping you've got a business that's maybe not as profitable as it needs to be, or maybe you're getting that business ready to sell. What do you have to do to get the business in shape to sell it? Just what can you do to help the daily operations to reach your goals and objectives? We do a lot of that here. We also do a lot of business valuations, and I'm trying to go through this quickly, where we help people figure out what a business is worth and why it's worth that. We also do a lot of litigation support work. We handle a lot of cases here for the state of South Carolina, the U.S. Attorney's Office, and other people. We're experts, meaning that it's a subject matter that we have some expertise in, and we testify for that. And we have attorneys like Charles taking shots at us, so we have to deal with that. But it's something we do. We also have a financial planning company that we do similar to what Alan does. It's probably very similar to what Alan does. And Alan go back a long way. Alan is awesome at what he does. But we do financial planning, which helps people decide their goals and objectives for retirement, and also making sure they got the documents that they need if something were to happen to them. And Charles will probably talk about that later, about how important those documents are. But simply put, we've grown. We've got 2 offices. I've also done other businesses. I've helped start a bank, two banks in South Carolina, sold those banks. Some of the people here might be younger enough to understand that I also helped start 4 jump facilities, those trampoline parks throughout the Southeast United States. So part of what I tell people is the reason I like accounting and accounting in particular is the language of business. And we help people understand that language is what we try to do. How do you make your business more successful? And that's the last thing is what makes us successful is not myself and my twin brother, Ronnie, who, just in case you want to know, he's the evil twin, I'm the good twin. It is that we have good people here who work hard and they do a good job for our staff. So that's pretty much what we do, a professional service, but try to make sure that if a client is successful, we feel like we're successful.
That's
Okay.
awesome. And Donnie, quick question for you, just as a review. Our last session, we talked about business valuation. So can you just give a quick summary of what the business evaluation is and why it's important for businesses to be thinking about a business evaluation, even if they're small?
Yeah, well, the business valuation, we do it for a number of reasons. A lot of times we may start that process if somebody wants to sell the business and we help them determine what the sales price needs to be. What's a good price, what a bad price. It may be somebody comes in and wants to buy it. But one of the main reasons you have a business valuation is because if you've got more than one partner in the business, and Charles can tell you this, and you need to value that business every year, every so often, because you do get in a dispute and somebody wants to leave, but you want to buy somebody out, you got to know what the value of that business is worth. It also gives you some indication about how successful you've been in the business. Most business valuations, you really have a few ways of doing it. You can figure out what the assets themselves are worth. Let's just say if the asset is a building, then you can have somebody appraise that building and just look at it from a reconstruction standpoint. But let's assume that you've got a great lease on that thing that's 30% above what would be fair market value in a normal situation. If that lease is a long-term lease, and the value of that building is a lot more than what it's going to cost to reconstruct it, because you've got that cash flow there. So when we look at valuations, we look at the value of the assets and we look at the cash flow, and that's the main two things we look at. But it gives you some indication of how your business is going, and I just think it's a good way of knowing every so often how you're doing in your business. And again, there's other purposes for it, but that's mainly it. Okay.
Awesome. Thank you. So if you missed that session, make sure that you watch the recording of the link that was dropped. And we went over the different steps of the business valuation. Even if you unfortunately experience a divorce, or if you're looking to exit, the business, or even if you're looking to have your kids succeed in the business. So that was a very great session. Okay, next slide, please. So when we're looking at estate planning, in terms of our business succession training, we're looking at several areas. We're looking at the business succession in terms of owners, who's going to succeed you. We're talking about legacy, gifts. We're talking about medical, disability, financial, the retirement, as well as charitable. Next slide. Now, we're getting ready to talk about what estate planning is, and I'm going to ask Donnie, Charles, and Alan, both for their respective industries, from financial planning to accounting and to tax, to tell you what type of estate planning they help their clients with. And so the slides will be made available to you afterwards. We may not hit each one of the slides, but we're going to go over all of the information in the slides through our conversation. All right, so Charles, we're going to start with you, and then we'll go to Donnie, then we'll go to Alan. And so really just talk to us about the type of estate planning work that you do with your clients. And then I want you to kind of give us an example of estate planning gone wrong. So, right, we were talking before we got on about Aretha Franklin. And if you look at so many of celebrities out there, they don't have proper estate planning. And when they pass, you have their family that's fighting over it. So we want to give you some real personal examples of estate planning that has gone wrong. So panelists, tell us about what estate planning you help your clients with, and give us some examples of estate planning gone wrong.
Well, for most of the work we've done has been fairly simple and straightforward, working with members from churches and things of that nature. I'm in Columbia, South Carolina. My home is a place called where I grew up, is Rembert. That's about 35, 40 miles from here, which makes it in South Carolina quite rural. And most of the wealth in the rural church is in the agricultural property that's owned by its members. And what happens is when people pass away without a will, families begin to crumble, arguing over who is to get what. And so those are some of the problems. And I'll get on the back end, I'll talk about some of the things that would happen when you engage in helping with wills, powers of attorney, and trust and things of that nature for in this setting. One of the things, and this is, I guess, the humor part, is that, and so everything is coming from the church, but you've got to take off your deacon's hat and put on your lawyer's hat, and you've got to ask questions. And I learned very early that I can't do it for the husband and the wife, because somebody starts whispering and someone starts twitching in the chair. And so at that point, you take a break, and then someone tells you that, well, I have this son over here, and I don't, I don't want anybody to necessarily know about him while I'm alive, but I want them to get something after I'm gone. Because of our rules of responsibility, I'm able to bow out of doing a will or any work for either of the two. And that's one of the things that I would have to do. And that caused me to bring legal services in where I had no contact. I was on the board, but I was not doing what I love to do, and that's hands-on, helping people solve problems, seeing what they want to have happen. So, but what we're doing and what estate planning simply is, it's projecting into the future and making these decisions now under the law in a way that whether you're here or not, those decisions will come to pass the way you projected them to be. And that's what it is. The problem that most people have is if I am going to put it off and I'll do it before I leave here. And we make plans, but we don't make reservations what time we're going to be leaving. And that's the thing that caused a little problem, folks. And we suggest to folks that you might want to go ahead while you going to church on Sunday, on Monday, you go to your lawyer's office and your accountant and your financial planner, and then really make a reservation so that you can leave when it's time to leave, and things will be in order. But what we would do is look at all of the assets, look at what they have. When I'm in any client relationship, I always ask, what do you want to see happen? What it is you want to accomplish? And I need to know what mark I'm shooting for. I need to tell them whether they can make that mark or whether they can't. You can't get there from here. Do you, looking at where the children are, what the children expect, who are the likely beneficiaries who you want to add, and how you begin to manipulate, the assets that you have and things of that nature. I mean, I don't want to bore you, but, Donnie, I do want you to know that Ronnie is not the evil twin, because Ronnie did some forensic work for us about 6 or 8 months ago. That was phenomenal. Just wanted to throw that out.
So you'll know, Charles, I coached him up on that. So just so you'll know.
That's fair. Okay, Renee, I've given the cook's tour, leaving something for others to do, if that's okay.
Mm-hmm. So I do just have one quick question for you. So for, is it required that you use an attorney to do your will, or can you use an online service? Pros and cons. Give us the pros and cons.
I'm sorry, go ahead. I didn't
I'll
hear
say
that.
the pros and cons of using an accountant versus using an online service.
I'm biased, so I'm not giving legal advice, but I would say that an attorney has malpractice insurance, and so they should stand behind their work. I've evaluated lots of things that were done, online, and some of them are pretty good. But the one thing about legal writing that we should know, legal writing is exactly what it is, and it's not what you want it to be. It is what it is what you meant. Not I was thinking about something else. And if you have beneficiaries in our state, and I'm only talking about our state, and I'm not giving legal advice, I'm just giving an illustration. Let me be very clear. In our state, if an heir at law is left out, it may require an explanation in the will or some acknowledgement of the existence of the heir at law. Because if the heir at law is not acknowledged in some way, that could make the will vulnerable to an attack.
So Charles, can you define heir at law just to make sure that everybody understands?
If you have children that you have acknowledged and everybody knows you have that child, and then something happened and you gone, and that a will pop up and that child ain't in that will, that child can go down to probate court and say, look here, I'm a child. Here are the funeral programs showing I was listed as a child and all these people died. Here are these things. And then I got 3 or 4 people, plus my mama still living. My point is, then the question is, was it an error that this person was left out?
Mhm.
And that determination can only be made with the available evidence in the probate court.
Mhm. And last
If the
question.
will should fail, then our intestacy laws will take over.
Okay. Last question, and then we'll move on to Donnie.
Sure.
So for a lot of people, they do not like facing death, whether it's life insurance, whether it's doing a will. So if you have a spouse that's kind of opposed to doing the work of a will, what advice would you give the spouse or the other spouse in getting them on board?
Well, South Carolina and most states are maybe very similar, but you want to look into what is the elective share for the spouse. And so if you, in a will, you have to, it's at 1/3, at least 1/3 the spouse is to receive. And so if I'm talking to the spouse about it, and I would just say, it's going to happen. Death is going to come anyway. And you know what you're doing now. A will does 2 things for you. It allows you to at least project what you would like to see happen while you're here and after you're gone. That's number 1. And number 2, it doesn't allow someone who has nothing to do with your family to come in and decide what happens. Now, if you want the guy from across the street to come in and run your business, don't do a will. If you want the people who live at this house to decide what's happening in your business, let's get around the table and see, can we make this work?
That was powerful. That was powerful. All right, drop in the chat and let me know, was that powerful information for you? Really an overview of the will, the things that you need to be thinking about in developing a will and why it is important. So drop in the chat and let me know if that was helpful. And also let me know if you have any questions. Okay, and so Donnie, if you could just talk to us about what estate planning is for your clients and what you help them with.
Well, part of it is, and I'm going to go back to something that you asked Charles, part of it is making sure they have the proper documents at death, okay, for the estate tax planning purposes. And Charles said it very easily. When you have a will, when you develop a will, you have a pen and a pencil paper, and you get to decide what goes in that will and who gets what. Now, I would tell you that I would advise everybody to have an attorney look at that document, because it may be, as he said, I call them nuances, but some things in the law that you have to be aware of. And if you try to just pull a will offline, you may make some error or something that might make the will contestable. And he did a good job of that. So I think using an attorney, even for a simple will, that's our advice to you. So with that said, we also try to get them, if they have many assets, to have a power of attorney to say if something happens to them, if they become incapacitated, who's going to take care of the assets in the business. And then you've got a healthcare power of attorney, which to some extent, simply put, is, or am I going to be left on a machine and not left on a machine, and that type of thing. And then you have the will and our trust. It says, after my death, this is what happens. And we get this all the time, in particular when somebody's trying to do a will, they don't want to think about their death. But just think about this. Charles has got it right. If you don't have a will, then the court's going to decide who gets what. And he just said, let's assume that you've got a spouse that you're alienated from, you don't want to leave them anything, but you only have a will. That spouse gets 1/3 of the estate. So the will is there to protect you and make sure that people get what they want, get what you want. We also look at it, and I'll just say, we look at it sometimes, a lot of times from a business standpoint. That will is something you really need, because you may have 4 children, for example, of which one child's working in the business, the other children are not working in the business. And so what the question is if you've got some stock in that business, do you want to leave it to all 4 children? Do you want to leave it to the child who's working in the business? And you've got to make those decisions. It's a little more complicated than that, but you look at your assets and decide who's going to be best at what. You may have one child that's a spendthrift that you want to put their money in trust so they can't get to it over a period of time. You may have another child that's very good with money, and you don't have to put it in a trust for them. So just, your children and people you're going to leave money to better than anybody else, and you've got to make those decisions. And I know those are tough decisions, but quite frankly, you need to make the right decision. And if they get upset about it, you're already dead. They can't talk to you about it. And so we tell people, do what you think's best and don't worry about it. So those are at least those documents you need to have. And I'll just say one thing. I got involved in a lawsuit years ago when they tried to use somebody pull the operating agreement, which is part of what we do with business tax planning. Business planning is to make sure that you in business somebody had an operating agreement. An operating agreement does a lot of things, but what it really says is if we get in a fight, who gets what and how do we handle that? And it's in writing. Well, they happen to pull the operating business out of North Carolina, not South Carolina, for one of these websites. And they used a North Carolina operating agreement as a basis of what they did, not a South Carolina operating agreement. But without getting an attorney involved, they paid a lot more in attorney fees trying to get that straightened out years later than they would have paid to get that to begin with. And the same thing with will or something like that. Every state law is a little bit different. So, but what we do with estate tax planning is you've got the assets here, and I don't want to bore you. We try to get everybody to get the assets, know what do you have and who's it going to. And for example, you have on your list here life insurance. You can have a will that says, I'm Donnie Burkett. I want to leave my life insurance to Alan Hancock, although I probably wouldn't do that because he just wasted. I didn't put it in trust for Alan, So, but if I say that in my will, it doesn't make any difference if he's not the beneficiary of my life insurance. They're going to go by who is the beneficiary of life insurance. The same thing for a retirement plan. Regardless of what you say in your will, retirement plan company is going to look at what your beneficiary form does. So when we do estate tax planning, we look at all the assets, who's the beneficiary, and how it's going to flow through either your will, your trust, your trust, or the life insurance you have and the retirement plans that you have. And I'll kind of stop with that, but it's really a matter of looking at your assets and deciding how you want to split them up and making sure they go the way you want them to go. Okay. We can do great estate tax planning for you. And if you've got $1 million of life insurance and you want to leave it to somebody, if you don't change that insurance policy to make it match that, it doesn't make any difference. So part of that is getting your assets together, decide who you want to give it to. And I just encourage everybody to use an attorney to get those documents drafted. Okay. Thanks.
All right, Donnie.
Let me say one more thing too. The other thing is, and I meant to say this, and Charles can talk about this more than I can. It's been a number of cases that we've had some things here to where somebody had the mom had some bank accounts, and they haven't her name, but the mom went to the hospital. One of the children went to the mom and said, I'm afraid you don't have, if you need some money, won't have any money. Won't you take all your bank accounts and stock funds and put them in joint names for me, and I'll take care of it if you need to write checks and that type thing. Well, that sounds like a simple thing to do, and it sounds like it makes sense to do that. But at that death, what that means is the other two kids don't get the bank account. They don't get the stocks. It goes directly to the ones that got the joint bank account with. And so we've seen those fights come up just unbelievable. And it's been some horrendous things about it, which is one of the reasons you look at how, when you do estate tax planning, you look at how things are titled. And Charles, you might want to speak more about that later, but that's something that we always try to do with estate tax planning. Okay. Because if I want my children to split my bank accounts 50-50, but it's in my name and only one of my child's name jointly, then that child's going to get the money. The other child's not entitled to the money. They might, out of the goodness of their heart, give them the money, but they might not either. So that's just the way it is. Thanks.
So, Donnie, I have a question for you. And then Charles, I do want you to talk about how things are titled, the importance of that. Donnie, I want to make sure that we are crystal clear for everybody that's on the call. So can you define when you talk about the assets? I know we have it on the screen, but kind of talk about the tangible and intangible assets, and then also defining what the trust is.
Well, so the assets that you have, we try to give you a list. A lot of it's on the, do you own a house? Whose name's it in? Real estate, automobiles. Get a list of all those items. In particular, I'll just talk about jewelry from a personal standpoint. My wife passed away almost 3 years ago. But 10 years before that, she sat on all the jewelry I'd given them. She made a list, and she was able to do that as a personal property note. And she got with the children, decided who wanted what with them, and I had a list of that. So just making sure. So sometimes jewelry and some household possessions have a sentimental value, not really a dollar value. And you can decide who gets those items. It doesn't have to be in the will. So just looking at your assets, the list is great. I don't think it's great, bank accounts, annuities, stocks, bonds, business interests in particular are what really creates a problem, because you get back to the valuation of that business. Let's assume that my dad passes away and he wants everything split 50-50, but I get the business interest. And if the business is valued at more than 50% of the value of the whole estate, then I've got to pay money to my brothers for that sport. So it's just a matter of looking at all the assets. So I think the list is good. The other thing is, and Charles can talk more about this than I can, you have a will, and that will is public knowledge, okay? I mean, you can go to a probate and get a copy of it in most instances, okay? My will is set up that way. I have a will, but it's what I consider a pour-over will. If my assets are in my trust name, which is a revocable trust, then that trust dictates what happens to those assets, and it's not part of the probate. So those assets are never listed in a probate. And it's a way of keeping something, I suppose, secret from the public eye. You may see that some movie star had passed away, or some celebrity passed away, and they only had $1 million in their estate, yet you thought they were worth 20 million. Well, that million is what was not in the trust name. The trust dictates, and the public does not have access to that trust. And you have the same decisions with the trust is, how is that money going to be split? So I have what I consider to be a simple way to pour over will, that if it's not in the trust name, the will dictates, but most of my stuff is in the name of the trust.
Donnie,
Sorry.
can you tell them the difference between a revocable trust and irrevocable trust?
Well, to me, revocable trust is what I have right now, because what happens is I can revoke it at any time. If one of my children make me mad, I can revoke it and change it. And I say that jokingly. But because one of my daughter's an attorney, she wouldn't let me do it. But a revocable trust means you can revoke it at any time before your death. An irrevocable trust means I put that money in there. I've decided the terms of that trust agreement. I put that asset in there, and I've got no control over it at this point in time. The trustee does. Charles, is that a good enough answer for that? The trustee has the decision, not me. Okay?
That's correct.
Yeah, I mean, with a revocable trust, I still control that asset. And just simply put, from a tax standpoint, if it's a revocable trust, it's disregarded for tax purposes. Even though it may be in a revocable trust name, it's on my personal tax return. It doesn't matter when I say disregard it. It's as if I owned it from a tax standpoint. But it helps with trust documents and state tax planning. I can tell you, a majority of our clients have a revocable trust for the reason I mentioned. Number one is it's not a public document you can get your hands on. Okay.
We have a quick question from Tara. She says, why would you choose an irrevocable trust over a revocable trust?
The irrevocable trust is that way because you can change it prior to your death. You can make changes to what the trust, to who gets what out of that revocable trust. If it's revocable, you still control it. If it's irrevocable, then your trustee controls what happens to that trust. Charles, is that a good enough answer? That's more of a legal question, I suppose.
Yeah, it's a good answer. The question, maybe I misunderstood, but why would you choose an irrevocable as opposed to a revocable? Often you want to get certain assets out of the way of the owner, so that if they have to seek governmental benefits or things like that, they may be beyond the look back provisions. Again, that's not legal advice. That's just this giving a distinction between the two instruments.
Yes, Charles, nothing that you say is legal advice, nothing at all. It is all for demonstrating. It's just, you just giving examples. So we want to say that 2 more times so that it's recorded. This is not legal advice. Okay, so in your opinion, because this is not legal advice, can you tell us the importance about making sure that things are titled properly?
I think Donnie said it pretty good, or not pretty good, said it really. Let's look at the policy behind it. The institutions that hold the money would like to dispose of it as clean and crisp and as soon as it can. The problem is when it's coming to an estate or going into a will, then it can get kind of murky sometimes if the will is contested and all of this kind of stuff. So if you go ahead and title it, the institution can write a check and it's over and done with, from that standpoint. So
okay.
you dispose of it at the time the instrument is prepared. I don't know whether that makes sense or not, and so when you get an asset, whether it's a car, whether it's a house, whether it's an insurance policy, whether it's stock, if you put POD, and who that's paid on death to who, or who is your successor in life. That's if you should die, if you put that on there, that dispose of it, it will not go through your will. And that when you close your eyes, it self-executes.
That sounds
So
good.
that's why the titling is so important. Institutions tend to prefer it because it's simple. It is between the institution and the beneficiary who gets the check, and that ends it, or who gets the property, that ends it.
Awesome. Okay, Alan, we're coming to you, but I have a question for the whole panel. And can I have the next slide, please? The question is for Louise. She says, I have concern. Basically, she has heartburn about estate planning for her married children. Her plan is where assets go to the blood or her blood, a bone of my bone children. And the question that she has is, can the married child include their spouse in the beneficiary without her knowledge?
Oh, that's a good one for you. And I mean,
Is it Lewis? I'm sorry, I said Louise. I'm sorry, Lewis. I'm sorry about that. Okay, so the question is, can the married child include their spouse in the beneficiary without my knowledge?
The beneficiary is going to be the person who the owner of the instrument identifies. The beneficiary cannot, they can take it and give it to somebody else, but they can't make somebody else a co-beneficiary.
and Charles, let me tag on that for a minute, and because I think it's a good question. One of the reasons we see trust, revocable trust set up, is because let's assume that you own a company that's got a lot of value, and it's a generational company that's been in the family's name for a lot of times. So if I'm the owner of that part of the company and I pass away, if I put that in a trust and it goes to my children's as a beneficiary, and they keep it in that trust, and they get married and have a divorce later on, it's not a marital asset. The other person can't get to that asset.
Right.
So the trust, and that's a simple, as Charles knows, it's a lot more complicated than that, but the trust protects it. And I do think that the question is a good question, and he did a great job. The beneficiary decides what happens to that asset. So what I'm saying is, let's assume that I leave my children a lot of money, and one of them's married, they have a great marriage, and that she gets the money that's not in trust, and she puts it in a joint bank account. The day she puts in that joint bank account, let's see, I leave her $1 million, she puts $1 million in a joint bank account, and she goes through the divorce, she starts divorce proceeding the next day, that is a marital asset. And her husband could be entitled to half of that money. If I have a trust and the money goes in trust and it stays in the trust name, it'd be hard to make it a marital asset. Right, Charles? I mean, that's part of the reason for having a trust, and that's a simple.
Yeah, that is correct. If you look at it, the property flows from the person, the original owner, to the beneficiary. And then whatever arrangement the beneficiary finds himself or herself in, that arrangement could be, whatever is received could be exposed to that arrangement. Marriage, judgments, lawsuits, all of those things that the two of them might be in, that could be implicated there. So by having the trust, the installation probably in all likelihood continues to stay. Someone asked the question, POD. POD would be on the side of where the election is made to appoint the beneficiary. The check's just going to be written to the beneficiary himself or herself. Is that clear?
And what Charles is saying is that it's important to make sure that in every asset that you have your beneficiary named. Tamika, was that clear? Okay, she said yes, it was. Okay, awesome. So Alan, we want you to kind of talk about what your role is in helping your clients prepare for estate planning.
Yeah, I started off making a list of all the points that Charles and Donnie were going to make because I didn't want to repeat stuff, and I was going to try to fill in some gaps. After listening, I think we've gotten such great detail at a very minutia level. I think what might be the most helpful for our registrants is if I kind of go back and give the 30,000 foot flyover, because if I was a registrant on this call, I think what I would want to hear is a very typical conversation where we have our clients. what is estate planning? It's a huge term. It can mean a lot of different things. You've just heard a lot of detail as to how it can sometimes work, but 70% or so, I think, of the applicant or registrants today said they didn't have an estate plan. So I'll talk for maybe 5 minutes about how we talk to our typical clients when the phrase estate planning comes up. And if it's not what y'all are after, if you have some specific questions, feel free to ask those. But the first thing I think you have to do, if you're sitting there and you're a business owner and you've managed to accumulate some assets, and the phrase somebody on a seminar says, do you have an estate plan? And you say no. There's a litmus test that I think you have to realize that you fall on one side of, and it has everything to do with the size of your estate. That's what Charles and Donnie are calling asset list and what have you. If you have amassed a high net worth, and right now, I think you could think in terms of, if you're single, $10-12 million. If you're married and most of your assets are considered those of your spouse, you could double that into the $20 million type range. That's a huge number. I know not a lot of people fit into that category. One of the problems with discussing some of the celebrities we talked about earlier is most of them do fit into that category. That is the threshold by which your estate might be taxed. We can answer a lot more questions if we need to. Just right now, hear me say, estate taxes are probably the most punitive and destructive thing that can happen in the transfer of wealth from one generation to the next. Most of you have probably heard the phrase sell the farm. That's where it came from. The large landowners in this country that had high wealth because of the land they owned, but basically lived hand to mouth, that had very little liquidity or cash on hand. They died. Estate tax got implemented and they had to pay the government within 9 months of death. They didn't have any cash. They literally had to sell the farm in order to create cash to pay the tax. If you think that your assets are of that level, then estate planning is just going to be different for you, because it involves an element of taxation that most of the rest of us don't have to deal with. I will say that that amount is referred to as the unified credit, and there's a suspicion that that amount got blown up way high. When I first started in my career, and therefore, Donnie had already been in many times. Charles is younger than me, and still wise and experienced, but younger than me. That number was $600,000. So the house that I live in today, as a value in and of itself, was already an estate tax problem. So the relief to the taxpayer lately is very, very real, but there's a suspicion that number's coming back down. All I could tell you to do, I think a decent percentage of you said you had a corporate attorney, stay in touch with that estate tax limit debate and make sure that you're on top of that. That's all I'll say about that side, because most of the people don't fit into that. The most of the detail you've heard from the other panelists falls into the other category, which is, what is estate planning if you don't expect to have to pay any taxes at your death? And the number one thing that we tell clients in that regard is, don't let estate planning be confused only with tax planning, so that if you don't have an estate of that size, you don't think you need to do any planning. You absolutely do. And it is just simply a matter of whatever Donnie and Charles both said, making sure that your assets are destined to go to where you want them to go, and think through all the different ramifications, like an adult child that is married. What do you want to have? Those are brilliant questions to ask. The single biggest thing that we tell our clients about estate planning below the estate tax limit is that most people erroneously think of the will as the primary tool in their estate planning. And what some of the detail you just heard from Charles and Donnie is that, in fact, legally, it is the last line of defense. There are a lot of ways that you can prepare for something to go to your assets, thereby accounting for almost every asset in your estate, and you may very realistically not even need a will. Even those methods that you're using, you still should talk to a qualified attorney and CPA and financial advisor to help you with that, because of the situation Donnie gave, where you could have a buy-sell agreement designed to handle the business interest, but it wasn't executed correctly. But the point to realize here is that if you're just working hard, if you've got a house, if you've got a retirement plan, a business banking account, and the ownership of your business, if that's the majority of your estate, which I assume probably covers a decent number of people on this call, you can have a beneficiary put on your retirement plan. You can have ownership of your house done with your spouse. You can arrange for all of those things that supersede the process of where the will comes in, and there may not be another asset left over for the will to handle. So if you go talk to an attorney and your assets are fairly narrow, then that may be the way that you choose to go. You still need the help of an attorney, but it doesn't necessarily mean that you have to sit down and go through the difficulty. We see so many clients that avoid the process of going to talk about a will because they have let the idea of a will become this monster in the closet, and they just don't want to talk about it. It doesn't have to be that way at all. There are still nuances to each one of those processes, but it absolutely can can include a method by which the final line of defense of the will is actually not that huge a part of what might be in your estate plan. It can be the opposite. If you have amassed some real estate, you've got several different properties that are income producing, if you've managed to put together 2 or 3 different LLCs because you have different partners and stuff like that, it's going to be a little bit harder to go through and title all of those things, or to have arrangements that would precede the will. And it may be, in fact, that you decide to do a will in that case. Like Donnie said, a pour over just simply pours everything over into a trust that can handle from there. The last point that I made, a question that I heard that I would just maybe nuance a little bit of an answer to. One of the primary reasons that you would have an irrevocable trust is if you are trying to remove that asset from your estate. Back to my earlier point, if you have a high net worth, if you think your estate might ultimately exceed one of those thresholds, you can actually move that out of your estate so that when you die, it's not included. And lastly, if you start to have some success in your business and people are starting to say you need to have some, you want to do the responsible thing and own some life insurance, be very, very careful. If you don't have the ownership of that life insurance, not even to mention the beneficiary, if you don't have the ownership of that life insurance set up correctly, then the death benefit can be included in your estate. So it's not that unusual. An individual person with $6 million of net worth is still been pretty successful, but it's not that unusual anymore. That person goes in and also insures themselves for $6 million to create some of that liquidity so they don't have to sell the farm. If they don't structure the ownership of that life insurance correctly, the $6 million death benefit is included in your estate, and all of a sudden you could be over that estate tax limit. So my hope in this little recap is to tell you, don't get scared of estate planning. Charles is nice, Donnie's nice. We all do this every day. We're pretty good at helping you walk through those steps. Go seek some help, whether it's going to wind up being a will or a trust, revocable, irrevocable, either one. There are really good ways of doing the planning and making sure that what you want to happen happens. And like Donnie and Charles both said, it's better for you to sit here and do it. It's not a fun conversation, but the state of South Carolina has intestacy laws that will do it for you if you don't. And I promise you, whatever you come up with over lunch one day is going to be better than what the state dictates for you. So is that helpful? I can be more specific, but I thought after listening to them, maybe just a general picture. If I was y'all thinking about how do I approach estate planning, that's how I would do it.
I think that was a great overview. And if you have questions, please drop your questions in the chat. I have a question for you, Alan, and then I have a question for the panel that someone asked. So Alan, what are the common mistakes that you see made? And Charles and Donnie, I'll ask you that as well, for clients that come to you. What are some of the mistakes that you see that they have made before coming to you, or that they make while they're working with you, maybe going against your advice?
Yeah, absolutely. Great question. I would say something happens in their life that gets them, revved up and ready to go. And they come in and they spend 2 hours in our office and we go through the spiel that I just went through. And we talk about all the different ways. A lot of times we even help advise them attorney they would want to go see. They promise to go see their CPA or their team of folks. And then they leave our office and life happens. And the information that we asked them for just doesn't come. Don't ignore it. That would be my number one single biggest piece of advice. If you don't have someone that you trust in that field, ask around to your colleagues. Somebody does. If there's 70% of this people on the call that don't have an estate plan, 30% do. Find out who they are, use word of mouth. If you have one of those people, if you have an attorney that you trust, I will almost guarantee you they have a CPA and a financial advisor they can recommend you to, and any of the three can go any different direction. But don't ignore it. It is so easy to get busy doing what you do every day, and there's no immediate pain. It's almost like a blockage of a major artery because you don't feel any pain until it's too late. And then whether it be death, whether it be a significant disability, whether it be mental incapacity, once you decide, wow, I wish I'd have done that planning, it's too late. That'd be my biggest advice. Don't ignore it.
That was good. Charles and Donnie?
Charles, go ahead. Yeah.
What's the question that we're responding to here? Let me be clear.
Charles,
Yes,
are you paying attention to us?
of course I am. But I want to answer the right question.
So the question that we were asking is kind of what's the biggest mistake that you've seen made for clients that you have worked with, either in the past when they were working with another attorney or with you?
Oh, gosh. The reason I asked you to restate the question is because I wanted to change my response.
You can change the response. That's fine. We're
Okay.
flexible.
My father was a school custodian. He died at 91 in 2017. He and my mom prepared their wills in 1984. And he would look at them, you know, from time to time, because he didn't, my mom was a college grad because he sent her to school. But he would look at the will from time to time and he would talk to me about it and just put it back and keep going. In 2003, he called me and wanted me to draft deeds for property that he owned. And first he told me, and this is the mistake, he told me he had a 60-acre farm in Kershaw County where I was born. He said, I want you to draft a deed for you to have it. And I wouldn't do it because my older brother was going to be upset. So he told me, he said, well, then draft the deed and give it to him. I didn't like that, but he wouldn't change his mind. The whole point is by 2005, all assets had been taken out of his name and out of my mom's name. And because he didn't know what would happen when, but his philosophy was give it to them now. If they have a question, they can come to me and I can tell them why I did what I did, which is a little contrary to what Donnie says, but you know, that's the way my father thought. At any rate, we did the pre-needs stuff, the powers of attorney, living will, and those kinds of things. My mom developed Alzheimer's within 3 or 4 years of that particular episode. She lived until 2015 and passed away. But my siblings and I had nothing to argue over at my father's death. And we can talk about the horrors of it's going wrong, but we can talk about someone in his late 40s, early 50s, preparing a will, disposing of, and looking down the road and looking into his fate and his future and making those decisions at the appropriate time. So there are a lot of bad things that can happen, but there are a lot of good things that can happen if it is done by the book. So I wanted to do that, Renee, that, you know, and forgive me for not giving the exciting horror stories, but
No, that was a great answer. And the reason why we just asked the question is really the urgency of doing it now, like not waiting and doing it now. So Donnie, before you give us your answer, and you can answer the question any kind of way you want to. Charles put me in check. However you want to answer the question is fine with us. But someone did ask earlier, is it best to talk about the interest, details, and intentions with beneficiaries before passing? So I know it's two kinds of thoughts of we'll do it after you die because you can't talk to me, and then kind of talking ahead. So I want to get the panel's perspective on just those two. It doesn't necessarily have to be your personal perspective, but just kind of two trains of thoughts.
Well, you know, it's interesting. I was going to speak to that. I'm gonna go back to what, let me say, Alan answered the question by saying, do it, get the will done. Okay, that's the biggest mistake people make. We talk, you don't have a deadline. You got to do taxes by a certain day. You don't have a deadline. And we have so many clients who just won't get it done for whatever reason. And in particular, the ones that I really give them a deadline if they come to see me, they've got 60 days to come back with a will if they have children. Otherwise, the court's going to decide something happens to do them, who's going to take care of their children. And I said, you know, you can argue about all you want, go see your attorney in 60 days. I want the will on my desk side. Because that's the issue. The issue is, and I'm just using children as an example as everything else, but you've got to get it done. You know, you got to be on the, and it maybe you have to have some discussions with your spouse. Maybe you want somebody to be the guardian of your children. The other spouse wants somebody else, but you want to decide those things, not somebody else deciding. Charles had said it earlier. You can have somebody else making those decisions you're gonna make. So the most important thing is do it, and it is do the will, do the healthcare power of attorney. If not, somebody else is gonna be making those decisions for you. Now, you know, it's a, you know, I can tell you, you know, one of the guys who used to work for me, the question you asked about, is it better to tell before or let them find out afterwards? That's the adult diaper answer. It depends, okay? It depends on the family. I can't tell you the right answer to that.
Right.
You know, I have some people who, they have such a good relationship with their children that they want the children to know exactly how they set up their estate, and it works out. I have others that they've had to make some difficult decisions about how to handle each child or each asset. And in that case, it's normally my opinion and their opinion that they don't want to go over that with anybody else. They'll let whoever the trustee is handle that. That's what they'll do. But it really depends on your children. It depends on the assets. I mean, if you split everything 1/3, 1/3, 1/3, it's probably not bad to do that. But the other issue you get into, and again, one of the guys who did a lot of estate tax planning is, he said this, and it's to some extent true to it. If the last parent passes away, we've seen a lot of fights over estates for no reason, for nothing. He said the last parent passes away, and it's 4 kids, and only one of them shows up at the funeral home to make the final arrangements. The other 3 are in their house taking what they want to have. They think the will may not have given them sometimes, and that's a fight. So the most important thing about having the will is to have the will and have it dictated, and even personal property have that dictated. But I don't. It does depend. It depends on your children. It depends on how you feel about it. Maybe you want to do it. I could also tell you, let me give you a personal horror story. I was personal representative of the state, and I had a lady's power of attorney, and she went to her sister who was older and told her, she was older, she told her sister that my death, you get my house. I'm gonna give you my house. Okay. Which is nice. And she decided she wanted to tell her sister that because the sister wanted the house. And her sister was elated about it. But a few years later, she had to go in assisted living. And I had a couple contested meetings with her son and her that insisted that I give them that house because she had said that she would, that he said, and she said that the woman had said that she said I would get the house. And I explained to him twice, and I would never talk to him again, is that only happened when she died. She was not dead yet. I had a power of attorney. And by God, I thought that the money from selling the house was going to be used to take care of it. It was. So that's a perfect example of why you don't do it. Because she said you get the house at my death, and the sister, she's not in the house. I know she's not dead, but you give me the house now. I want the house. She said I could have it. I just got at the second meeting, I said, I'm not talking anymore about this. You go do what you need to do. But I'm not giving you the house. She's not dead yet. The power of attorney dictates before that, it's not a power of attorney, it's in the will. And by the time she passed away, I sold the house to use some of the money to take care of assisted living. That's the way it works. So that's my answer. Okay.
And Donnie, that we have a question that is going to tie right into it, because it says, is there a way to create a donor advised fund for family use, allowing the funds to benefit needy senior age family members as the charity?
I don't, the way we look at Alec, the way we look at donor advised funds, most of them are something that you set up and it goes into a charitable organization. They give away the money. I don't know if you can do it for your, that would be, wouldn't be a charity. You could set up a trust, and the trust would dictate how the money's worked. So and we talked about why have a trust, and I've had an attorney explain it to me this way. One reason you have a trust, when you set up that trust, and especially if it's a trust in your will, and you pass away, you dictate in that trust how that money is going to be spent, who's going to get what, and how it's going to be spent. And he explained it as then you're reaching out from the grave and making sure that money is being spent the way you want it to be spent. So you could certainly probably set up a trust in your estate and set some money up there and dictate to the trustee how that money is going to be spent. I've never seen it that way, but you can do it. But that trustee is so important because you're going to leave that trustee has a lot of powers after you pass away. But if you do the document right, that allows you to reach out from the grave and tell the trustee how to spend that money, what to do with it. And Charles, somebody may have something to add to it, but that's one of the reasons we like the trust too, as part of the will.
Now, I agree. The will makes one statement, and that's the end. The trust continues to speak until its purpose is resolved.
That's a great way. That's a great way to say it. Alan, do you have anything that you want to add to everything that we were just discussing?
No, they did great. I would maybe add on to that one last question about donor advised funds and the charitable side of it. We tell our clients all the time, the good news is, talented attorneys like Charles can do whatever you want. The bad news is talented attorneys like Charles can do whatever you want, meaning it's imperative that you sit down and figure out what that is. In terms of charitable remainder trusts generally fall under two categories: charitable remainder annuity trust, which is commonly called CRAT or CRUT, is a unit trust. The basic difference there is you're in fixed income type investments that we know what interest rate they're going to spit out versus a more diversified portfolio of stuff that can have up years and down years. Most of that matters because of the income that can be pulled off of that trust. Could you set up a scenario where that income off of that trust was not just for the donor's lifetime, but also to care for an elder person or have it managed in a trustee type relationship? I'm sure you can. I don't know that I've seen that. Generally, the income stream dies with the donor, or grantor is what we would call it. And therefore that gift is released on to whatever charitable entity was there. But I would never say no way. Some attorney somehow, I'm sure, could help figure that out. If you wanted to have the income coming off of a charitable trust benefit not just you, but some loved ones or someone that needed care in a trustee type arrangement.
Okay, we thank you. We did have a question that says, what guidelines should you use to pick a good estate planning attorney? Charles, we understand that you cannot handle everybody, but what are some guidelines for picking a good estate planning attorney?
You would the same thing. You would look for somebody who has a good reputation. Could be someone you've been referred to. Your accountant will likely know somebody. Your financial planner will likely know somebody. If you already have a relationship with one of these professionals that you trust, that usually is the gateway to get to the others, because we all live in the same community. And so that would be the thing. But you look for somebody who's been doing it for a while and who has a good reputation and things of that nature, because you are trusting them with I guess your life's work, quite frankly.
Can I back up for a minute to it? That's great. And Alan mentioned taxes a while back about how it may or may not be a taxable estate. And I want to kind of tag on that. Just to understand that if you do have a taxable estate, the taxable portion of it will probably be taxed at about 45%. And then he was talking about, you got land worth $1 million and you don't have $450,000 of cash to pay it. So just to understand the taxes, once you become a taxable estate, it's pretty punitive. It's that type of thing. But the big thing is let's also assume that most property passes from the estate to the beneficiary with a step up in basis, meaning if I've got stocks and bonds in a brokerage account, that's just a brokerage account, at the date of my death, then it becomes revalued at whatever that value is then. If my children sell it, it may not be much of a gain. However, for a retirement account in particular, an IRA or any type of retirement account, you don't get that step up in basis. So here's my example. I tell people, you got an estate, you got $1 million in assets, and y'all in non-retirement assets, you got $1 million in retirement assets. Well, at your death, those retirement assets are going to be taxed when they're distributed to the beneficiary. They're going to pay income tax on that, not estate tax. So they're not getting $1 million. They're getting $1 million less that tax bracket. Okay. But if this is, say, for example, to make it simple, my goal was to give half of my estate to charity. Then I would just say, I want to give my retirement account to charity. And they would get the whole $1 million tax free because the charity didn't pay taxes. And the other $1 million would go to my kids. Well, if I gave them a retirement account, they might net $600 out of it, and the other asset would go to charity. So we try to, part of estate tax planning, Alan kind of mentioned, is trying to decide the tax aspects of it, of what's the best way to do what your goals and directives are. It's kind of simple. It sounds simple, but having that beneficiary the way you want the beneficiary to match whatever you want to do with your assets from a charitable standpoint is a good thing to do. Okay. Sorry. I meant to mention that earlier, but we got past me.
No, that was really good. And so I actually have a question, and I don't know if this is legal or not. That's why I thought about it when Donnie said it. So if you have your retirement planning that you want to leave to a charity, can it be a charity that's run by your family?
Yes, but most of the times it's a family charity set up before death. Okay.
Okay.
Have something set up before death, and you can leave that money to them.
Okay.
A lot of the
Okay.
wealthy clients have set up some type of nonprofit and use that money
Yeah.
for. I'm on the board of a nonprofit, for example, that a family set up that the individual not passed away, but he gave a good bit of money to it.
Okay.
And what we do and what we give money is to people who want to bring people to Christ. That's our whole purpose of it, to organizations and people who bring money to Christ. And in that situation, he is giving money to charity at his death, but charity's already set up. Most of the time, I've never seen one after death. Most of the time it's set up before, and that is a
Yeah.
beneficiary.
Okay.
There are rules. There are times I've seen an existing charity that was run by a family where a gift is going to be made. If it's a 503c, it's you could maybe expect a heightened level of oversight. But as long as they're complying with the different rules and regulations and their books are fairly transparent, I've seen situations where that wasn't a huge problem.
That's correct.
You say run by the family. If there's somebody in a key role, obviously that gift will probably get looked at. And look, the higher the estate, the more love you're gonna get from the service, IRS. But yeah, I have seen that happen before too. So, and T. Renee, I would add to the person who asked, how do you pick such a person? I have just one thing we tell our clients all the time. Again, with my medical analogy, I'd think about it like a doctor. If you get opportunity to go see an attorney, we tell our clients all the time, you can assume the attorney knows the law. You don't get to where Charles is in life without knowing that. You don't get to where Donnie is without knowing the tax law. What they don't know is you. So their first entire meeting, I would be impressed. I would want to work with somebody that asked me a lot of questions. They know what a revocable versus irrevocable trust is. They don't know that your oldest son is hardworking, does the right thing, and your other two children, you're not so sure about. I'm a psychology guy. That's a birth order thing. I'm not disparaging anybody's children, but Donnie broke the mold. He's a firstborn that, every now and then there's an outlier, but usually that firstborn is hardworking. You could do that kind of thing. That's the kind of stuff an attorney should be asking you. They should want to know who you are before they try to tell you. If you go in to meet with an attorney and he asks you to answer 6 questions and says, here's a draft of a will, I'd be a little bit skeptical of that. So that's what we tell our clients on a daily basis.
I think that was great. So basically, you're wanting to have an attorney that wants to get to know you personally so that they can advise and they can guide you.
Yeah,
Not
the
just a
nuances,
boilerplate
that's
template.
that's where the real success is had, in those nuances. Somebody asked earlier from the chat room, what happens if I have a child who's an adult spouse and I want to be able to protect them from that. I don't know. There were several answers to that. They were all great. The short answer is you can set up your trust or have your trustee directed to where those assets are protected. You can have income off of it, but that's one of the most common questions we get. How do I protect a spouse of a child, from gaining some of these assets? And you always need an attorney to do this stuff correctly. But if you have an attorney, that's going to be a fairly typical question they get, and it is easily doable.
Charles, you gonna say something? I saw you come off mute.
Yeah, I appreciate what Alan just said. We just had one, I guess, in the last maybe few months, where the beneficiary was had done well in school and had enough, but had taken up with this guy who was not exactly really good. And the dad was worried about, if I give her the house, what's going to happen. And the reality is, unless you want to do a trust and get somebody else involved, your daughter is going to make the decision. And you can only take that decision away from her if you create some other instrument that she would have to negotiate with, from that standpoint. And I'm not aware of any other mechanism to do that. So, it's just hard to save somebody from themselves. The will is not the instrument to do it. The trust comes close to it. But when you say a trust, you're talking about introducing another person into the transaction, and that's the trustee.
I think that was a great point. All right, so we have 5 minutes left, and I wanted to find out if you all had any last minute questions. If so, I want you to drop them in the chat. We're gonna just go through the slides real quickly, just so you can see that we've covered the information that was in the slide through our conversation. So we already talked about the benefits of estate planning, what your basic estate planning documents are. We talked about the will, the revocable trust, financial power of attorney, medical power of attorney, the living will, will and the appointing of a guardian for your children. Next slide. We also talked about trust, which Charles just finished talking about, which is making sure that all of your aspects are disposed via trust so that it would not go through probate. Next slide. And you all will get the slides afterwards. We talked about the benefits of the trust, maintaining control over the estate, avoiding probate, reducing income taxes, etc. Next slide. We also talked about the philanthropic legacy, and we just finished talking about that in reference to having your estates go to a charity or a nonprofit organization, religious church, or et cetera, and the reason why you want to set that up prior to death. Next slide. And then, of course, we had extensive conversations about the wills and what the will does cover. And then we also talked about what the will does not cover when we talked about the trust. All right, next slide. All right, we talked about the financial power of attorney, being able to make financial decisions. Next slide. We also talked about what the benefits are for a financial power of attorney. And we talked about the last will and testament, which is different when you have like a living will and then a last will and testament. Next slide. We talked about revisiting your estate planning, right? If you have a loss of a loved one, if you have children that are growing up, if you become a grandparent or parent, basically any decision where you want to change how your assets are being handled. Next slide. And then updating your estate plan is really revisiting it when you have things that come up. And these are the 4 steps to go through. And we all talked about the horror stories of next slide of probate and why we want to avoid it. And that's basically where the court decides what happens to your assets or to your estate if you do not have an estate plan. And then Charles and Donnie both talked a little bit about the South Carolina law. And disability planning, I don't think if we talked anything about it. So panelists, do you have, next slide, do you have anything that you want to add in reference to, well, we did talk about the disability planning as far as a medical power of attorney, making sure that you are saying exactly what you want to happen. I do think Donnie said it earlier about making sure that you're not living on life support if you don't want to be on life support. So really just thinking about these decisions ahead of time.
I will say one thing about disability planning just real quick though.
Yes.
It's more likely that you become disabled. We have a lot of people who may spend money on life insurance that need to also spend a little money on disability insurance through their employer. So if you've got a chance to buy disability insurance, look at that, because the worst thing that happen to you is if you're the provider of the family, you become disabled, then you don't have life insurance coming in, your family, there's no way for your family to be supported. So part of the financial planning is to look at what your disability pay. If you become disabled, what's the plan? Do you have insurance for that? So if you work for somebody that has that, look at that as one of the options you look at, because that's when you can't provide for your family in life. That's just a terrible situation if you're the provider. Okay, thanks.
That is very good. So making sure that you have disability insurance. Absolutely. Next slide. Next slide, please. And this is really just a summary, a step-by-step for you of what it is that you do when someone dies. All right, next slide. And we want you to start the conversation. And these are some things about how to talk to your family. I know we said it depends on the type of family that you have, if you have the conversation now or if you don't, but these are some steps to help you start the conversation. Next slide. And we did have a question. So Wendell said, my son is on the spectrum and may need guidance beyond my death. What do you recommend for people in this position? And that's to the panelists. And then Camille, you can close us out.
Yeah, I would just say to Wendell that there are a lot of different trust type options designed specifically for special needs children. The biggest issue that you need to think through, Wendell, is just who, if there's a person already in place, that makes it easier, but who you would want to care for, who you would want to be you. And if you're married and have a spouse, obviously those are the first 2 lines of defense. But after that, if something were to happen to y'all in a common accident, who do you want to have the authority? Who's willing to take the authority to help them? And then there's several different trust options for special needs arrangements where you could have. The only other thing I would add would be you may want to think through the person that might be in charge of taking care of your son may not be the person that you want handling the money. Nothing against them. It's just that there's different skills to do both. So you could have a a guardian appointed inside of one of those trusts to actually care for your son every day, but you have somebody with a little more acumen that's designed to handle the money, make sure that it's producing income, and make sure that guardian has what they need to take care of your son.
That was a great answer. So I want you to drop in the chat if this was helpful. Was this helpful for you? The seminar was very helpful. Thank you for giving us the tools and inspiration to do these things sooner than later. Awesome. Final slide for the upcoming seminar. And Camille, it is on you. Thank you so much, panelists.
Thanks,
Thank you.
Renee.
Thank
Thank
you,
you.
T. Renee, for leading the discussion. Thank you to our experienced panelists for volunteering your services today. I myself learned a lot. So we look forward to all of you returning for our final session on Thursday, July 27th, where we will discuss how to prepare for the transition or to exit your business. We will also provide you with a succession planning toolkit so that you have what you need in order to get started. Thank you again and have a great day.
Thank you.
Bye,
Thank you.
everybody. Have a great one. Bye-bye.
Bye-bye.
And yes, Kelly, it was recorded. It was recorded. Bye-bye.